Good morning, everyone. I'm going to cover two topics this morning. As your last two lectures, the first will be on maritime neutrality, which is chapter 11, I believe, in the Newport Manual. And then the next block will be on the law of prize, which is in chapter 9 of the manual. So it's just some of the sources. Your primary sources are your Hague Convention, customary international law. If you have an armed conflict in the Americas, for example, there might be a regional convention like this that has applicability as well. So you have to see what the sources of your law are. What is neutrality? What is a neutral? Basically, all states that are not party to an international armed conflict are going to be considered as neutral states. And what it does is it defines a legal relationship between belligerent states that are engaged in the conflict and neutral states that are not taking part in the conflict. The law of neutrality imposes both duties and rights upon both the neutrals and the belligerents, and what it's designed to do is to protect the sovereignty of the neutral state while at the same time preventing an escalation of the conflict. Now, what happened to the law of neutrality after the UN Charter was adopted? I mean, some people will say, well, the law of neutrality no longer exists. Well, that's not true, but there may be a situation where the Security Council takes enforcement action under Chapter 7 of the UN Charter, and in those situations, the Charter requires that all member states of the UN provide assistance to the Security Council to enforce those measures. That is incompatible with the traditional law of neutrality of impartiality, because you will be providing troops, for example, that may be fighting on one side of the conflict against the other belligerent. So in this type of a situation, the UN Charter requirements supersede the law of neutrality for those states that participate in the enforcement action. There is a provision in Article 50 of the Charter which allows a state to come to the Security Council and say, hey, China is my biggest trading partner. If I provide assistance to you in enforcement actions against China, these are going to be the repercussions. Therefore, I'm requesting that I not be required to provide that assistance. So there are provisions that would allow a state to be exempt from its obligations under the Charter. After World War I, there was a movement to outlaw war as a matter of national policy. Things like the Kellogg-Briand Pact, the League of Nations, things of that nature. And the question then becomes, in that situation, some states have taken the position that a neutral can discriminate in favor of the victim state. So let's say in the case of the Ukraine-Russia conflict, everyone would agree that Russia was the aggressor in that conflict. Therefore, states would say, because the Ukraine is the victim of aggression, we are going to be able to provide that state with war supplies, for example. And even though that violates the obligation of strict impartiality and abstention under the traditional law of neutrality, that's okay. So this qualified neutrality applies and allows for the provision of war-related materials to one of the belligerents in violation of the strict applicability of impartiality and abstention. This is not a universally recognized principle. It's my personal opinion. I don't think it's a good position, although my country adopts it. You can see here, for the age of Ukraine, there's been over 40 states that have applied qualified neutrality and are providing weapons and ammunition to the Ukrainians. The European Union, as well as the United States, has imposed severe economic sanctions on the Russian Federation. So all these things are clearly inconsistent with the traditional law of neutrality with regards to abstention and impartiality. So again, in my opinion, this is only as good as the belligerent will accept the fact that there's a thing such as qualified neutrality. Russia has indicated that if they so choose, they can exercise their right as a belligerent of self-help against these countries that are providing assistance to Ukraine in violation of the law of neutrality. So let's say there's a convoy of trucks loaded with ammunition heading from Poland to Ukraine. Could Russia attack that convoy in Poland while it's en route to Ukraine? Russia would say yes, because they would be exercising their right of self-help, because Poland is violating the law of neutrality, and they are not taking measures to prevent that violation. Again, the other camp basically says only in the situation where the Security Council has identified an aggressor will this concept of qualified neutrality apply. So if there's enforcement action being adopted by the Security Council under Chapter 7, then the strict applicability of the law of neutrality will not apply. Absent a decision by the Security Council that there's been an aggressor, the law of neutrality continues to apply for these states that apply this test to whether or not neutrality survives in post-charter era. Again, this really isn't realistic in a conflict with any of the permanent 5 members of the Security Council. So if China were to go to war, or the U.S. would go to war, or in this case Russia is at war, they're going to veto any type of UN Security Council resolution that would identify them as an aggressor. So this is not realistic in a situation where one of the parties to the conflict holds a veto in the Security Council. All right, so what is neutral territory? It includes all the land territory of the neutral state, the internal waters, the territorial sea, archipelagic waters of the neutral state. As Professor Krasa mentioned, it does not include the contiguous zone or the exclusive economic zone or the high seas. Those are not considered neutral waters. And it also includes the national airspace of a neutral state, or in other words, the airspace that is above the territorial sea and above the land territory of the neutral state. So the general rule is that neutral territory and neutral airspace are inviolable. So in that case, belligerent aircraft cannot fly into national airspace of a belligerent without violating the neutral's neutrality. You can't fire a missile. Let's say you got China wants to fire a missile at Australia during an armed conflict in Southeast Asia, and they fire their missile and it goes through the Indonesian airspace. Can they do that? No, that would be a violation of Indonesia's neutrality. The other thing is that neutrals have to treat all belligerents impartially. So if you're going to allow a belligerent to, for example, enter your ports, you have to also open your ports to the other belligerents as well. As I mentioned earlier, the law of neutrality imposes both duties and rights for the belligerents as well as for the neutrals. So in this case, the belligerents have a duty to respect the inviolability of the neutral state, and that's reflected in the Hague Convention. So belligerent warships can't use neutral ports or waters as a base of operation. So they couldn't sit in the territorial sea of a neutral state and engage in combat against the belligerent, a neighboring belligerent that shares a border with the neutral state. They can't make use of neutral ports or territorial waters to replenish or increase their supplies of war materials or armaments or complete their crews. And again, this is subject to certain exceptions that the neutral state may allow. Belligerent warships cannot use neutral states or archipelagic sea lanes as a place of sanctuary. So you've already learned that a belligerent warship can engage in transit passage or in archipelagic sea lanes passage through an international strait or through archipelagic sea lanes of neutral states. So that's okay, but what they can't do is they know that there's a enemy warship sitting at the other end of the strait, so they loiter in the strait or in the archipelagic sea lane for long periods of time to avoid. So they're using it as a place of sanctuary, so they're not attacked by the other belligerent warship. So they can't do that. There's no right to exercise visit and search in neutral states or archipelagic sea lanes. And the belligerent warships cannot engage in any acts of hostility, including capture or the right of visit and search in neutral waters. Again, that's subject to this right of self-help, which I'll talk about in a little while. So what is self-help? As I mentioned, if the neutral state is either unable or unwilling to enforce its neutrality, then the aggrieved belligerent can take the necessary action or necessary measures in neutral territory or neutral waters to counter the acts of the enemy. And that includes the use of force. So let's say the situation that I used as an example before, where you have a belligerent warship loitering in the Strait of Malacca because it doesn't want to get attacked when it comes out on the other side, and Malaysia and Indonesia aren't doing anything to make that ship continue on its voyage, then can China attack that warship in the Strait of Malacca because the neutral states are either unable or unwilling to force the belligerent to stop using the strait as a place of sanctuary. And there's no requirement to notify the neutral state in advance that you're going to use force to enforce your right of self-help. Example, the Almach incident that Professor McLaughlin just talked about, it also has a neutrality aspect to it because the ship, the German ship had POWs on board. The Norwegians did not do anything to get those people off board. So the British warship was ordered to board the vessel and free the POWs while the ship was in Norwegian waters. So an example of the exercising the right of self-help during an international armed conflict, because the Norwegians were unable or unwilling to free the POWs. There is no prohibition on belligerent warships to act in self-defense if they are attacked while they are transiting to or from neutral ports or in neutral territorial seas, or if they are engaged in archipelagic sea lanes passage or transit passage. If they are attacked by one of the belligerents while they're in neutral water, they have a right of self-defense, and that would not violate their duties under the law of neutrality. Port visits, the neutral state can allow belligerent warships to visit their neutral ports, but the rule is that they can only remain in port for 24 hours unless there's a reason for them to stay longer. So they may have suffered a casualty, for example, that requires them 2 or 3 days to make repairs so that they can get underway. Then they can stay past the 24-hour rule. So as soon as the reason for the delay is over, then they have an immediate duty to depart as soon as possible from that neutral port. Another rule for port visits: there can be no more than 3 belligerent warships of the same nation in the port at the same time. If an opposing belligerent are present, if opposing belligerents are in the same port at the same time, then at least 24 hours must elapse between the one ship leaving of the one belligerent and the other ship for the other belligerent leaving. They can't leave at the same time. There has to be a period of 24 hours between the departures if they have both been in port at the same time. And they normally will leave based on the order that they arrive. So the first one in will be the first one out if they're both in port at the same time. Additionally, a belligerent warship cannot leave a neutral port before 24 hours if there's a merchant ship of the enemy that's been in port and is leaving port, then the other belligerent warship has to wait 24 hours before it can depart that port. As I mentioned, there are some exceptions for repairs and replenishment in neutral ports. So the belligerent warships in a neutral port can carry out repairs that are absolutely necessary, and that will be determined by the neutral state to render the vessel seaworthy to be able to get underway. They can also take on food to the peace standard, and as well as fuel to enable them to reach a nearest port in their own country. And they can also use bunker fuel for that purpose if the neutral state has adopted that as a means of providing fuel. And finally, once the British warship has taken on fuel in a neutral port, then it cannot go back to a port of that same neutral country within 3 months to replenish or take on supplies in that neutral state. Mere passage. In the law of the sea, we have innocent passage. In the law of naval warfare, we have mere passage. It's basically the same thing. The difference being is that the neutral state has to allow it. There's no requirement that the neutral state allow for the mere passage of belligerent warships through its territorial sea. It's perfectly permissible for the belligerent or for the neutral to say no belligerent warships may transit my territorial sea during the armed conflict. Alternatively, they can suspend access. The neutral can suspend access to the territorial sea or archipelagic waters as long as they do so on an impartial basis. So they can't say, state A, you can't come into my territorial sea, but state B, you can come into my territorial sea. That's not permissible. If they're going to open the territorial sea up or their ports up, they have to do so to both sides of the conflict. I'm not going to go through this, but just remember, neutral, if these are neutral waters, then belligerent warships have a right of transit passage through straits used for international navigation that cannot be impeded by the neutral states. And same thing with regards to archipelagic sea lanes passage. The neutral archipelagic state cannot impede the use of archipelagic sea lanes for the purposes of archipelagic sea lanes passage to belligerent warships. EEZ is not considered neutral waters. Again, Professor Kraska drove that point home during his lecture. So that means that belligerents can engage in hostilities against the other belligerents, and they can engage in other belligerent rights such as visit and search while in neutral EEZs. When conducting any type of military operation in the EEZ, the belligerents will, consistent with military necessity and operational requirements, respect the rights and duties of the neutral state. That is not the same thing as the due regard obligation in peacetime. The due regard obligation in peacetime under Article 58 of the Convention does not apply during an international armed conflict with regards to the belligerents. Okay, so what are some of the neutral obligations under the law of neutrality? Principal duties of the neutral state are abstention, which means that they will abstain from providing the belligerent with war-related materials. And their second duty is impartiality, which means they will exercise their rights and duties in a non-discriminatory basis toward all the belligerents involved in the armed conflict. With regards to the rights of the neutral state, they may use force to resist attempts to violate their neutrality. So for example, again, this example of a belligerent warship loitering in the territorial sea or loitering in an archipelagic sea lane or in an international strait, the neutral authorities inform the belligerent to leave because they are violating their neutrality. So there may be a situation where the neutral state could actually use force to require that belligerent warship to leave its waters because it's violating the neutrality of that state. And if they do use force to enforce their neutrality, that's not considered an act that would make them a party to the armed conflict. Again, the neutral states can close their ports if they so desire. They're not required to. But if they do close them, they have to close them on a non-discriminatory basis to all of the belligerents. If they decide to close their ports at the beginning of hostilities, then they got to provide notice to any belligerent warship that might be in port and give them 24 hours to depart the port. And likewise, if neutral ports remain open to the belligerents, the neutral state can prohibit belligerent vessels that have failed to comply with orders and regulations made by the neutral to use its ports in the future. As I mentioned, the territorial sea of the neutral can be closed by the neutral, again, on a non-discriminatory basis, and therefore suspend mere passage of belligerent warships through the territorial sea, except as that may be required by distress or force majeure. That would require an exception to the closure of the territorial sea. And again, if the same thing with ports, if they close the territorial sea to the passage of belligerent warships, then they got to provide notice to the belligerents and allow them 24 hours to get their ships out of the territorial sea. There's a duty on the part of the neutrals to prevent the belligerents from violating their neutrality. So in that case, the neutral has an affirmative obligation to exercise surveillance using all means at its disposal to prevent any violations of its neutrality by the belligerents. And as we discussed earlier, if the neutral state is unable or unwilling to stop the violations of its neutrality, then the belligerent may exercise the right of self-help, to include the use of force in some circumstances. Again, self-help can range anywhere from a diplomatic protest all the way up to a use of force. And the main obligations of the neutral are impartiality. So they have to apply impartially all conditions and restrictions or prohibitions to all the belligerents equally. And with regards to abstention, unless you buy into the concept of qualified neutrality, the neutral state is prohibited from supplying a belligerent directly or indirectly any type of war-related material, munitions and things of that nature. Again, if a neutral state violates its duty to be impartial or to abstain in providing war supplies to the other belligerent, that doesn't necessarily mean they become a party to the conflict. Just because you have violated your neutrality by providing weapons and things of that nature, you are in breach of your obligations as a neutral state, but that doesn't necessarily make you a party to the conflict. Now, if the neutral were to attack a belligerent, the other belligerent, or let's say provide actionable intelligence to one of the belligerents that would allow the belligerent to successfully engage a target, then those would be circumstances where the neutral has now crossed the line and would be considered a party to the international armed conflict. The neutral also has an obligation to prevent the fitting out or arming of any vessel that's within its jurisdiction if the neutral has a reasonable reason to believe that the vessel is going to engage in hostile operations against the state in which that is at peace with the neutral state. Similarly, it has to prevent the departure of any vessel that, if it has a reasonable belief that it's going to engage in hostile operations, and have been adapted entirely or partly within its jurisdiction for use to prosecute the war. Prize we'll talk about later. This is just some general rules about prize. The belligerent can't bring a prize into a neutral port unless it's because it's unseaworthy or because of force majeure, let's say bad weather, or it requires to refuel. The prize has to leave as soon as these circumstances no longer exist. And if the prize doesn't leave, then the neutral state can order it to leave. And if the prize, if the belligerent does not remove the prize from the neutral state's ports, then the neutral state has an obligation to seize the vessel and release the prize with its officers and crew, and in turn, the belligerent's prize crew. The neutrals also may be in a position to detain belligerent warships. So if a belligerent warship doesn't leave a neutral port when it's not entitled to remain, so let's say they get a notification that they're supposed to leave in 24 hours, they don't leave, then the neutral state is entitled and in some cases required to detain the warship and its officers and crew. The officers and crew can be kept on board the vessel once it's detained, or on board another vessel or on land, and may be subject to measures of restriction while they're in the neutral state. And there's a special rule for officers that can be left at liberty if they give their word that they will not leave the neutral territory without the permission of the neutral state. And that's it for the law of neutrality. Okay, prize. A lot of the stuff in prize has already been talked about by a lot of the other professors, so we're going to blow through this pretty quickly. So what is a prize? It's vessels or good that are captured at sea and are liable to condemnation by the capturing belligerent. The belligerent has a right to capture enemy merchant vessels and civil aircraft, and can capture neutral vessels and civil aircraft for cause. So if the neutral does something that would allow it to be captured, and capture is normally going to be achieved by taking control of the vessel by exercising the belligerent right of visit and search. Now, just because you have boarded a vessel, you find that it's carrying contraband, for example, it would be something that you could condemn as prize, doesn't mean that you have to do it. It's purely discretionary on the part of the belligerent as to whether or not it is going to take that vessel and the cargo and adjudicate it for prize in a prize court. There may be other situations that Professor von Heining mentioned, that you may just sink the vessel if it's not practicable for the belligerent to take that vessel back to a port to go through the prize adjudication process. So prize courts are used to condemn captured vessels or aircraft or goods. They have to be adjudicated in a prize court. In the United States, the U.S. district courts have primary jurisdiction over prize. We have an entire chapter in our U.S. code that deals with prize law. So the domestic courts of the capturing belligerent are authorized to make prize adjudications that are brought before its court within a reasonable amount of time. If the capture is adjudicated as lawful, then the belligerent state can take ownership of the vessel and or the cargo and convert it to its own use. If the court adjudicates that it was not lawful to seize that vessel and cargo or aircraft, then the court can order that the vessel and its cargo be released, or it could order that the vessel owner be compensated for any loss or damage that resulted from the unlawful capture. As I mentioned, it's whether or not you're going to condemn something as a prize is going to be discretionary with the belligerent. It's a very time-consuming evolution, so it's not going to, if you have scarce resources, like let's say you don't have enough prize crews and things of that nature, and you're not going to actually adjudicate a prize, then you can destroy it. Again, as Professor von Heineck mentioned, only after you have placed the passenger's crew and the ship's papers in a place of safety. Then you can go ahead and sink it. And that stems from the 1936 London Protocol. Now, the UK takes the position that you cannot destroy a neutral prize, so not enemy prize, but a neutral prize, if it's not possible for you to adjudicate it as prize, then in the UK they would have to release that neutral vessel. I think Professor Kraska also mentioned booty of war in his lecture. So you have to distinguish prize or from captured items from booty of war. So if a belligerent captures enemy warships, naval auxiliaries, or other government vessels or aircraft, then those pieces of military equipment are booty of war. They're not prize. If an enemy merchant vessel or civil aircraft becomes a military object and is captured, it's also a booty of war. It does not have to be adjudicated as prize. And again, unlike the condemnation in prize, the transfer of ownership over these military objects is not required to be adjudicated by a prize court. Exempt from booty of war are military hospital ships, medical aircraft, or other medical transports. So we're going to determine the character of a vessel. This has already been discussed as well. But if you're flying an enemy flag, then you're automatically going to be considered as conclusive evidence that you are of enemy character, so whether it be an enemy warship or enemy merchant vessel. If you're flying a neutral flag, then that's only prima facie evidence that you're of your neutral character. So a belligerent can still conduct visit and search to determine your true character, even though you're flying a neutral flag. And if you are a neutral vessel, you could still be considered an enemy merchant vessel if you are registered in the belligerent state, the other belligerent state. If you're owned by a belligerent a private corporation, for example, in the other belligerent, if you're under charter of the other belligerent, or other criteria that might be defined by the belligerent state. So enemy merchant vessels are subject to capture as well as their cargo, and they become a lawful prize after they've been adjudicated. The only restriction is you cannot capture and prize in neutral waters, and there are certain vessels and aircraft that are going to be exempt from capture and may not be condemned under any circumstances unless those vessels or aircraft have violated their specific protective status. So enemy merchant ships that are exempt from capture, you can see here the cartel ships. The only one I'm going to talk about is, let's say this one, small coastal vessels. So and this is important in the context of the maritime militia, because the maritime militia is really comprised of three different categories of vessels. One is small coastal fishing vessels, which are usually about 10 meters or less. They normally engage in artisanal fishing by local personnel. Then they have a second category that are deep sea fishing vessels that engage in more commercial type fishing. And then you have a third category, which is a vessel that is devoted entirely to supporting the PLA during an armed conflict. So that third category is always going to be targetable because of its nature. The other two are going to be targetable depending on how they are used, because a deep sea fishing vessel, which is not protected, could be laying mines, for example, or transporting troops. By its use, it could therefore be considered to be engaged in conduct that would allow it to be targeted. And these small coastal vessels are normally used by the PLA to conduct harbor defense. They might also be used to lay mines. So if they are engaged in that type of activity where they are providing support to the enemy, then they lose their protected status as being exempt from capture. And then they are not only subject to capture, but they can also be targeted and destroyed based on their conduct. An example of a safe conduct arrangement is a World War II example where you have the U.S. wanted to supply relief supplies to Allied POWs in Southeast Asia. And they were going to do that by providing goods to the Red Cross in another country where it would be picked up by Japanese merchant vessels, and they would move that those goods to Southeast Asia. One of the vessels that was used was the Awa Maru, and you can see here it was distinctly marked with white crosses and on both the funnels as well as on the hull, and it had running lights which would be on at all times at night, so that would be easily distinguishable. The Navy, U.S. Navy, sent a message out to all of its submarines and fleet, because remember, at this point in the war, we were doing just like the Germans were doing. Any merchant vessel that belonged to Japan, we were sinking. So it was unrestricted submarine warfare by the United States. So a message was sent out to the U.S. Submarine fleet saying that, here's the exact route and the schedule that the Awa Maru is going to be taking. Here's how, give you a description of the ship, and directing the submarines to allow that vessel to pass, because it had been, safe conduct had been arranged between the two countries. Well, the USS Queenfish apparently didn't get the message, and sank the Awa Maru while it was on this on the route that had been identified between the parties. The CO of the Queenfish was court-martialed and was convicted for negligence as a result of that incident. As I mentioned, vessels lose their exempt status from capture if they're used for any purpose other than the protected purposes. So the commander can exercise visit and search to determine the nature of the vessel's activity or status. And a vessel will retain its exempt status if it's being innocently employed in their normal role, if they don't commit acts that are harmful to the enemy, they obey regulations imposed by the naval commander operating in the area, they immediately submit to identification and inspection when required, and they do not intentionally hamper the movement of other combatants that are in the area. Neutral merchant vessels are also subject to capture under certain circumstances. So if a belligerent warship undertakes visit and search with respect to a neutral vessel, if that vessel is engaged in any of this activity, then they are subject to capture and they can be adjudicated as prize. So again, acting on behalf of the enemy, operating under enemy control, being used as a auxiliary, for example, to carry enemy troops, if they're carrying contraband, etc. So what is contraband? It's not illegal for a ship to carry contraband. However, a neutral vessel does take on some risk if it's carrying contraband. If it during a visit and search contraband is discovered, it can be captured as prize. And if under certain circumstances, if it engages in certain conduct, can be attacked as opposed to just being captured. And contraband is defined as any item that may be of use to the enemy in waging war and which is ultimately destined for the enemy. Types of contraband. Prior to World War II, there was two types of contraband, absolute and conditional contraband. That distinction has pretty much become obsolete over time since World War II. So if you have something that is absolute contraband, weapons, things like that, then those do not have to be on a contraband list in order for them to be considered contraband, and they can be automatically captured and condemned as prize if on a neutral vessel, and goods may be captured and condemned only where there's reasonable suspicion that they may be used in support of the enemy's warfighting efforts. One way to facilitate the identification of contraband is to provide contraband lists. So anything that's on the list will be liable to capture and condemnation. The other alternative is not to have a contraband list, but to have a list of free goods, which would be things that are not subject to capture by the belligerents. So here's an example during the tanker war between Iran and Iraq during the 1980s. Here's the list of contraband items that Iran declared: all goods, merchandise, means of transport, and equipment belonging to a state or to state at war with Iran, and merchandise and means of transfer belonging to neutral states or their nationals or nationals of the belligerent state, if they could effectively contribute to increasing the combat power of the enemy or their final destination, either directly or via intermediaries in a state at war with Iran, etc. So again, very broad. That covers almost everything that you can imagine. So not a very helpful contraband list on the part of Iran, but that's just an example that of states that might provide a contraband list during an armed conflict. Enemy destination: the contraband that can be seized in prize if the destination is into the territory under enemy control. And you have this rule of continuous voyage, that the contraband can be seized if their ultimate destination is the territory under the control of the enemy. So if you have a ship that's going to port A, and those goods from port A are then going to be transferred over to the belligerent, the vessel could be, and cargo could be seized while it's en route to port A because of this continuous voyage rule. One way to, again, to facilitate determining whether a ship is carrying contraband or not is to issue navigation certificates. And what these things are a belligerent will have an official in neutral ports that will give a merchant vessel a navigation certificate that indicates that the vessel is not carrying contraband. The only problem with this is that that's prima facie evidence that you're not carrying contraband, but the other belligerent still has a right of visit and search, so they can still stop you and conduct visit and search, and if they find contraband on board, they can seize it and condemn it as prize. There are certain neutral merchant vessels that are exempt from visit and search. And so if you have neutral vessels that are under a neutral convoy of the same nationality, if these three conditions are met, then that neutral merchant vessel is not subject to visit and search by one of the belligerents. So if the vessel is bound for a neutral port under the convoy of an accompanying neutral warship of the same nationality, during the Persian Gulf War, for example, the U.S. escorted U.S. flagged vessels in through the Straits of Hormuz up to Kuwait, and other ships of other flags would join in the back of the convoy, and so they would think they would get the same protection, but in reality, those vessels would not be protected because they're not the same nationality as the United States. So that's first condition. Second condition, the warship has to warrant that the vessel is not carrying contraband. And third, the convoy commander has to provide information about the vessel that would otherwise have been obtained by the other belligerent through visit and search of that merchant vessel. These neutral vessels are exempt from visit and search, so they're vessels that are entitled to sovereign immunity are exempt from capture as prize, and may not be subject to visit and search. And then that includes these government vessels that are engaged in non-commercial service. So the belligerent right of visit and search, a belligerent is always entitled to conduct visit and search of any neutral merchant vessel or aircraft anywhere in the world outside of neutral waters or neutral airspace. So neutral merchant vessels are always going to be subject to the right of visit and search, so that the belligerent can determine the true character of that merchant vessel to determine whether it has enemy or neutral character. It can be used to verify the nature of the ship's cargo. So is it carrying contraband, for example? Or how is it being employed? Are there foreign troops on board? So is it being used as an auxiliary, etc. This is an exception to, again, the freedom of navigation that you have in the law of the sea convention. Another example of where, as Professor Krass mentioned, the law of naval warfare is lex specialis and will trump a law of the sea convention principle that would otherwise apply in peacetime. And again, given the operational constraints of visit and search, again, it's a time-consuming evolution. It requires certain qualified individuals to do it. In the U.S. Navy, for example, not anybody can conduct visit and search. It has to be conducted by a specialized team that has been trained specifically to engage in visit and search, or by the Navy SEALs. Or if we have a Coast Guard detachment embarked on the warship, they can be used. But only in those circumstances can a U.S. Navy vessel conduct visit and search of a neutral vessel. So normally, then, it's only if there's a real suspicion that this vessel may be engaged in some kind of illicit conduct will the belligerents engage in visit and search. Diversion, that's one other thing that the belligerents can do. They can divert merchant vessels from their course for one of two reasons. One is to prevent the neutral from committing an unneutral act. So let's say there's a blockade of the coast and you have a neutral vessel that's coming and it's approaching the blockade line. The belligerent that has imposed a blockade can divert the merchant vessel away from the blockade area, or it can also be diverted in order to be able to carry out visit and search in a safer place. Let's say there's a storm at sea, so you want to be able to conduct an inspection of the vessel in port rather than at sea for safety reasons. And the consent of the neutral vessel is not required before it can be diverted to another port. Resistance. Enemy merchant vessels are not required to comply with orders of the other belligerent, for diversion or for visit and search. But if they refuse to do so, they can be attacked. So resistance by the enemy merchant vessel can result in it becoming a military object, and it can be attacked. Neutral merchant vessels are, however, required to comply with the orders, including with diversion and with an order to stop for purposes of visit and search. Failure to do so may entitle the belligerent to consider whether or not the neutral is engaged in actively resisting, and then subject to enforcement action by the belligerent. If the enemy merchant vessel refuses to comply with an order to stop, or if a neutral vessel actively resists, for example, repelling boarders, it can be warned that it might be attacked if it persists and be engaged as a legitimate or lawful target. So there's a distinction between active and passive resistance. Active resistance, for example, would be firing upon the blockade force, or continuing to attempt the breach of a blockade, or attempting to ram or enforcing belligerent's warship. We saw that a lot in World War II, where British merchant ships were ordered by the British Navy to actually ram German vessels that were attempting to engage in visit and search.